Hello everyone. We are going to discuss paper 1 of Patent Agent Exam 2016. We'll see the answers with explanation. Part A, it comprises 30 multiple choice questions with 2 marks each and with only one option correct. So you have to choose the best option for these 30 questions. So this part A is for 60 marks. So to start with, question number 1, which section refers to power of controller to make orders regarding substitution of applicants? The options are section 19, 20, 21, and 22. The correct answer for this is section 20. Question number 2, the condoning of delay or irregularity in procedure within the power of controller can be requested by way of filing. Your 4 options: form 30, the form which is applicable wherein there is no specific form is mentioned, petition, affidavit, and form 4. Now the correct answer to this is petition. To condone the delay or irregularity, you have to file a petition basically with the Indian Patent Office. Now this is under rule 6.6. If you check specifically, the rule 6.6 says that the petition is required in this case. Now the revision of terms and condition of CL can be filed under the provision of section 88. That's the correct answer for this. Any applicant residing in UK files patent application in India claiming priority from the first application filed in UK, and the term would be granted in India would be, the term of the granted patent in India would be, you have 4 options: 20 years from priority, 20 years from filing in India, 20 years from grant in India, and 20 years from date of publication of grant in India. Here in the correct answer is 20 years from the date of filing the application in India. Remember that in case of PCT, the term is always calculated from the PCT filing date. In case of convention, the term is always calculated from the convention filing date in India. And in case of Indian, the term is calculated from the date of filing of the patent application. Now, ground for opposition to restoration of a patent. Now, these are different grounds than the grounds for opposition of a patent application. Basically, herein you have 4 options: non-working of a patent, invention is already in the public domain, failure to pay the renewal fee, which was intentional. Basic intentionally the applicant didn't pay the renewal fees, and none of the above. This is the correct answer: C, failure to pay the renewal fee. To pay the renewal fee was intentional basically. And under section 61, the other option is the delay in the making of the application, undue delay in the making of the restoration of the patent basically. Question number 6, the time period for paying the renewal fee without extension as per section 142(4) after the recordal of patent is 3 months time. So once a patent gets granted, you have 3 months time within which you can pay the renewal fee which is remaining. This is without extension actually. Okay, so you need to remember all the timelines basically, because there have been repeated questions on the timelines, specifically in terms of question paper 1, that is multiple choice questions, as well as in paper 2 first part. There are a lot of questions with respect to the timelines. So I would recommend you to prepare a chart basically for all the timelines till date, from filing to renewal, the entire prosecution process, and that would be something you can remember those, because these are crucial timelines basically. Now, a new ester of a known medicine with a carboxylic acid chain is patentable if, now as per section 3D, if it shows significantly improved therapeutic efficacy than the said acid. This again refers to the Glivec case of Novartis versus Union of India, wherein Supreme Court pointed out that efficacy has to be read in view of therapeutic efficacy, basically. Question 8, which form is required to be filed for expedited examination under section 11b and rule 24c? The correct answer is form 18a. Form 18a is filed for the request for expedited examination of a patent application. Which of the following decisions or orders or directions are appealable before IPAB? Which are the orders which are appealable before IPAB? Here in the answer is section 15 and section 16. I just want to inform everyone here in that the IPAB is already dissolved. It stands dissolved as per the Tribunal Reforms Act 2021. Okay. Now question 10, the controller neither shall refuse to grant a patent nor a patent shall be revoked by reason only of circumstances under either A or B. That is under, so the exceptions to anticipation, the chapter which relates to exceptions to anticipation, section 29, 30, 31 and 32 for this. So these things are covered under section 34. Under section 34, the controller would not refuse or revoke the patent only because of these conditions. So these are exceptions to anticipation, basically. Also try to understand the concept of anticipation, because unless and until you understand the concept of anticipation, you may not be in a position to understand the entire chapter as such. Now, grant of compulsory license for manufacture and export of patented pharmaceutical products to any country having insufficient or no manufacturing capability in the pharma sector to address the public health problems falls under the following provision of the Patent Act. So granting of a compulsory license for export, okay, in those countries wherein there is an insufficient or no manufacturing capacity, and it is to address the public health problems. This comes under section 92A. Section 92A, under which the pharmaceutical products for the export purpose. Okay. Question 12. The information that a patent is required to submit regarding the extent to which the patented invention has been commercially used in India is under section 146(2) rule 131(1), and this you have to submit as a part of form 27. Form 27 is the form which has been in discussion in last few years because of various reasons, but this is that form and section which is required for providing the commercial availability of the products for those products which are patented. If a central government is of the opinion that the patent is against the public interest, you're given 4 options. Central government has to pursue the patentee to withdraw the product. The central government, after giving an opportunity of being heard, make a declaration to that effect in official gazette, and thereupon patent shall be revoked. Third option, central government has no power to revoke. And fourth option is the central government has to approach the IPAS. Now, in this case, the correct option is B. Under section 66, the central government has the power actually to revoke a patent after the patentee is heard, basically. Okay, this is in case of the patent is against the public interest. The patent application can be withdrawn once request is filed under rule 74A and 26 by submitting form 29. So the form for withdrawal of a patent application is form 29. On successful opposition to the patent under section 25(2), which is a post-grant opposition on ground for wrongful obtaining, the opponent has to file the application for the change of the changing the name of the patentee in his favor. So for example, I have filed a post grant opposition, and the applicant has had wrongfully obtained the invention from me. In that case, I have to submit one form, and that form is form 12 actually. Now under section 21J of Indian Patent Act, inventive step means invention that involves technical advancement as compared to existing knowledge or economic significance or both, and that makes the invention not obvious, what we call as an inventive step, basically non-obviousness to a person's ordinary skilled in the art. The person skilled in the art is the person who has a general knowledge about that technologies basically. So for example, if the invention is related to fertilizer composition, a person who has understanding of the fertilizer compositions, scientist, not a IP guy, would be working as a person ordinary skilled in the art in that case. International application means application filed under WTO, CBD, PCT, or Budapest Treaty. So it is, the answer is PCT basically. Now the Budapest Treaty is for the microorganisms depository bodies basically, and PCT, Patent Cooperation Treaty, is the one which is for the patent application. Discovery of new galaxy is not patentable under section 3C of the Indian Patent Act, because the mere discovery of a scientific, so section 3C says mere discovery of a scientific principle or formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. So a galaxy is already available, someone has discovered it, it may not be patentable as such. So that's your question number 18. Question number, so this was the question which also got repeated in 2018 basically. I also want to let you know that many a times we have seen this, that the questions get repeated from previous year's question paper, specifically in the paper 1, the multiple choice. So it is always recommended that you go through the previous year's question paper. Under which section of the Patent Act the examiner to whom the application is referred conducts the examination? This is under section 12. Remember that in case of a examination, the examination is carried out by an examiner, and the controller issues the examination report accordingly. So examination is always carried out by the examiner at the patent office. A granted patent gives the patentee the right to claim damages now from the priority date, grant date, date of filing of complete specification, or from date of publication in the official journal. The correct answer to this is date of publication. This is the significance of publication of an application basically. That's the reason many of the companies or applicants go for early publication, because it triggers a lot of activities like the damages can be claimed after publication. Secondly, it also triggers your examination if you have already filed the request for examination. Thirdly, when your invention is available in the public domain, potential licensee can also come to know about your invention, and that way you can actually get a licensing deal as well. That's the reason, here in many people go for the early publication. But a granted patent gives the right to claim damages. The answer for this is public from publication under section 11A7. Which section of Patent Act refers to mention of inventor as such in patent certificate? This is under section 28. Opposition board is constituted on receipt of notice of opposition, receipt of written statement of opposition, reply statement of opposition, and reply evidence. The correct answer is notice of opposition for this. This is under section 25(3) for post grant opposition. Remember that the opposition board is something which is for post grant opposition only, because herein the opponent is also party to the proceedings basically, and only a person interested can file. the post grant opposition. Also remember that in case of opposition board, even an examiner can be part of the opposition board. That examiner is the one who if the examiner, one examiner has carried out the examination for that application, he cannot be part of that particular opposition board basically. Now, the display of an invention with the consent of true and first inventor at industrial or other exhibition, which has been notified by central government under section 31, shall not be treated as an anticipation. Under section 31, any display in exhibition notified by central government is an exception to anticipation if the application is for the patent is made by him not later than 12 months time actually. So if the applicant files the application within 12 months, then only it is accepted. So the other options are later than 12, 18 and later than 18 months. Question 24, date of recordal is same as that of recording the date of grant in the register of patent. Okay, the date of recordal is same as that of recording the date of grant in the register of patent. Time limit to oppose the application for amendment of patent. This is not opposition to patent, this is opposition to amendment of patent after it is granted, is generally 3 months from the publication of that amendment basically. This is different from, as I said, the opposition for the patent application or opposition which is a post grant opposition. For that it is different from post grant opposition as well. This is for the amendment. Someone does amendment in the patent, that can be opposed basically. Application for termination of a compulsory licensing is under section 94. Now question 27, as per the Indian Patent Act, a resident in India is free to file an application for patent in a foreign country without first filing an application for patent for the same invention in India. The patents are jurisdictional rights. A patent which is applicable or enforceable in India may not be enforceable in other countries. That's the reason if you are working in multiple jurisdiction, you would file different patents in different countries. And the question herein is, a resident in India is free to file. He can file application for patent in foreign country without first filing in the Indian territory only under certain special circumstances. The third thing is, can file an application for patent in foreign country only after PCT. And the last option is none of the above, which is the correct option. The Indian Patent Act allows a resident in India to file a patent application outside India under section 39 only after seeking the foreign filing permission requirement as such. This is under section 39, which is also called as a foreign filing license actually. Question 28, a patentee may offer to surrender his patent within a period of 1 year from grant, anytime from the grant, before paying renewal fee, after paying renewal fee. Now the correct answer is anytime from the grant of patent. A patentee can surrender the patent under section 63 anytime from the grant of the patent. Question 29, as per Indian Patent Act, patentee means person for the time being entered in on the register as grantee, applicant, inventor, both the applicant and the inventor as named in form 1 of second schedule. The correct answer to this is patentee is the person for the time being entered onto register as the grantee or proprietor of the patent basically. Question 30, prior art does not include knowledge disclosed in publication. Yes, it is a prior art. Knowledge disclosed only to closed group, bound by NDAs, non-disclosure, also called as confidential disclosure agreements. This is the correct answer, because all others, the one disclosed in patent, the one available in public domain, the one in publication, all is a prior art. So question 30, the right answer is B. Now part B is of 10 marks, 10 questions, and each has 1 mark. Statement 1 is true, 2 is false. You have to write A. So there are 2 statements given basically, and you have to choose which one is correct, which one is false. If first is true and second is false, choose A. Both are sorry, second first is false, second is true, then you choose B. Both are false, choose C. Both are correct, choose D. Now question 31. So this is applicable for question 31 to 40. Application filed applicant filed a provisional specification and filed a request for early publication before filing the complete specification. His application will be published within 1 month from the date of such request, notwithstanding his failure to file a complete specification till that time. This is a false statement. A provisional cannot be published. First thing. Second thing is that you cannot file a request for early publication without filing the complete specification. His application can be published only after filing complete specification. So the statement 1 is false, statement 2 is true. Statement 1 is false, statement 2 is true. Question 32. Any person can make a request to controller for mention as inventor in patent anytime during the life of a patent. The mention of any person as inventor under section 28 shall not confer or derogate from any rights under the patent. Now in this case, the statement 1 is false, statement 2 is correct. Any person cannot make a request to controller for mention. There are specific person only who can actually, who are involved in that invention, can actually go for mention as inventor in the patent during the life of a patent. Question 30. So this is as per the mention of invention as such in a patent, that is section 28. Question 33. If nature of biological material is not understood from the description, or if it is not available publicly, the application shall be completed depositing the material to an IDA, International Depository Authority, under Budapest Treaty, not later than the date of filing in India, and a reference there shall be made in the specification within the prescribed period. So this statement and the second statement, there is no need for deposition of biological material mentioned in the application and specification. The first statement is true. If you are using biological material, then you have to get that accession number. You have to if that material is new, you have to submit the deposit it to the IDA under the Budapest Treaty before filing, and then get a reference for that actually. So it is mandatory procedure, and the statement 1 is correct, 2 is false. Question 34. Convention can be filed within 12 months from the earliest priority application. This is a true statement. Convention can be filed beyond 12 months from earliest priority by taking extension. This is not allowed. Second statement is false. First statement is true. Question 35. Application for a patent for an invention may be made by any person claiming to be the first and true inventor. This is a true statement. Application for a patent may be made by any person being the assignee of the person claiming to be the true and first applicant. The true and first applicant, that is actually true and first inventor, has to be there. So the second statement is false. First statement is true. Question 36. For the grant of a compulsory license, the reasonable requirement of public shall not be deemed not to have been met if, by the reason of refusal of patentee to grant a license on a reasonable terms, the establishment or development of commercial activities in India is prejudiced. And the second statement is, for the grant of compulsory license, the reasonable requirement of public shall not be have been met if, by the reason of refusal of the patentee to grant a license on a reasonable terms, the demand for the patented article has not been met to an adequate extent. Actually, in this case, if you see, these are basic requirements for the compulsory license, and both of these are actually the correct statements. So you can actually go through one of our upcoming videos for the compulsory licensing case laws, wherein all these things are discussed in detail. Applicant is entitled to file a divisional only after issuance of FER. An applicant is entitled to file divisional at any time before the grant if he so desires. So the correct answer is 2. The second statement is true, and the first statement is false. Actually, divisional can be filed at any time before the grant. Question 38, application for patent of addition shall be made before grant of patent for the main invention. Patent of main invention is granted after the grant of patent of addition. Both the statements are false. Patent of addition can be made anytime during the term of a main invention, first thing, and main invention gets granted then only your second patent, that is patent of addition, can get granted. So the what we also typically call in divisional and patent of addition are the extension applications basically. Okay, that's not the standard term used by the patent office, but that's the term used in the technical community basically to understand the unity of invention and improvement or modification. They will relate it to the same invention basically. So it's not a standard term, but we call it as an extension application. Question 39, request for examination can be filed by any interested person. Request for examination can be filed only by the applicant, inventor, or assignee. Most of the times the request for examination is filed by applicant, inventor, or assignee, but the Patent Act allows any interested person to file request for examination. In fact, when you file request for examination, that point of during the e-filing, you always have that option: person interested, applicant, or inventor, or his assignee basically. So the statement, because statement 2 says no other person, that's the reason it is false. Statement 1 is correct. Declaration of inventorship should be filed on the day of filing of the specification and provisional specification, and declaration of inventorship should be filed for convention application. Now these are two separate statements. Statement 1 is false. For provisional, declaration of inventorship is not required. You can file the declaration of inventorship, and for complete application, any kind of complete application, it is mandatory. So be it a convention application, complete application, or a national phase application, it is mandatory. So this is question number 40. Now part C has 10 questions with more than one option correct. So you have to select more than one option. Herein you don't need to select most correct, but all correct options you have to choose. Every question has got 3 marks. Now if any person uses his place of business the words patent office, he is punishable with, the options given are imprisonment up to 6 months, imprisonment or fine, imprisonment and fine, warning by the controller. Herein the correct answer are A, B, C. So there can be 3 separate things: imprisonment, imprisonment or fine, and imprisonment and fine. So you have to select all these 3, then only you would be getting those 3 marks. So this is under section 121. Question 42. A provisional was filed on 1st Jan 2010. Another provisional was filed on 1st March 2010. Thereafter, due to the request of the applicant, the controller allowed to cognate the applications, club the application, and to file a single complete specification. Now, what are the valid dates in terms of submission of complete specification? Now, in this case, all the dates which are 1 year from the first priority are valid dates, and after the second provisional. First priority say 1 year, and after the second provisional, 1st Feb 2011 it is not the right date because like it is more than 1 year. 1/1/2011 is the right option. 31/12/2010 is the right option. 27/2/2011, it's more than 1 year. So the correct answer for this is B and C. Anytime after the first priority within 1 year, actually beyond 1 year, it's not allowed. Definition of a startup includes an entity with following attributes. Now this is something which is been changed recently, but we'll see the answer to this first. Like the entity which has 5 years not lapsed from the date of incorporation, the turnover is not exceeding 25 crores. It's working towards innovation development, commercialization of new product driven by IP, and even after expiration of 5 years, turnover is less than 5 crores. The correct answer to this particular question is A, B, and C. So this was the definition of startup in 2018 when this question was asked. As on today, we have different requirements. Company age has been now included as 10 years. Company type, earlier it was private limited company as well as the LLP, limited liability partnership, but now even a normal partnership firm is allowed to be a startup. Annual turnover, which was that point of time 25 cr, now 100 cr, is a annual turnover which is allowed under the definition of a startup. It has to be original entity. I mean, it should not be formed by splitting up or reconstructing an already existing business. The innovative and scalability thing, the innovation part, C part, is already there. So the startup definition is changed now. But then during that point of time, in 2016, when this question paper was there, that point of time, these were the three things which were covered under the Startup India. Okay, now the expedited examination request can be filed by an applicant when the applicant is a startup company certified in India, international applicant who had chosen India as ISA, applicant who has requested for early publication, and applicant who has entered NP in 31 months. So the correct answer to this is A and B. Early publication doesn't give you the right to go for a expedited examination. Also, the national phase entry doesn't give you the right to expedited examination. So a startup company as well as an international applicant who had chosen India as ISA. Some of the others are government institutes, government organizations, as well as if it is the application is filed by individuals and not the corporates. In that case, if one of the individual or inventor is a female, in that case you can go for the expedited examination. Now question 45, ordinary patent application is filed on 1st Jan 2010. Request under 11B and rule 24 can be filed. Now this is a bit tricky unless and until you know what is a request under 11B. You may not be in a position to answer this. And request under section 11B is request for examination, which is usually filed within 48 months from the date of filing of the application, or it is filed 6 months from date of revocation of the secrecy direction, whichever is later. 60 months from priority is a wrong answer. That's the reason even D is the wrong answer. Question 46. Under section 40, if a person contravenes any directions under section 35 or 39, the application shall be abandoned and the patent granted if would be revoked under section 64 actually. So this is so A and B are the correct answer. Patent of Mr. X was seized due to non-payment of renewal fees. His rival Y comes to know that X has applied for restoration. On which grounds Y can oppose restoration of the patent? There was another question asked about restoration of patent, opposition to the restoration. Herein, the two clauses are failure to pay renewal fees not unintentional. That means the fees was intentionally not paid, and the delay are more than 18 months basically. So that's the correct answer. X and Y make patent application in India, naming A as the true and first inventor. The application should be examined when X files RFE, Y files RFE, A files RFE, Z files RFE. Now we just saw that request for examination can be filed by anyone. So the correct answer in this case is A, B, C, D. You have to choose all the options. Question 49. X decides to oppose the amendment after grant to the description. X decide to oppose the amendment after grant. Okay. To a patent obtained by his rival Y. The option before him is file form 14 as well as request for hearing after filing form 14. Under file form 14, you can actually oppose the amendment after the grant of the description of a patent basically. Last question, question 50. Application for review of controller's decision and an application for setting aside an order passed ex parte can be filed under the provision of section 77 1F and 1G. These are the two correct options for this. So thank you so much for joining for this particular video, watching this video. Do subscribe to our YouTube channel as well as you can watch other videos with respect to the patent agent exam preparation. We would be uploading all the videos for previous years question papers answer actually, and that would be something which would be useful for you. Thank you so much for joining once again.